Suppose Congress enacted a law, and the Supreme Court ruled it constitutional, requiring American families to attend church services at least 3 times a month. Should we obey such a law? Or suppose you were a jury member during the 1850s and a free person was on trial for assisting a runaway slave in clear violation of the Fugitive Slave Act. Would you have voted to punish the person? Well, a moral person would find each of those laws either morally repugnant or a clear violation of the Constitution. What I'm saying is that moral people cannot rely solely on the courts to establish what's right or wrong. In the words of Thomas Jefferson, to consider judges as the ultimate arbiters of all constitutional questions is a very dangerous doctrine, and indeed one that would place us under the despotism of an oligarchy. In 1798, Jefferson and Madison drafted what's known as the Kentucky and Virginia resolutions. And they said, now listen to this, folks, they said, quote, resolved that the several states composing the United States of America are not united on the principle of unlimited submission to their general government. And whensoever the general government assumes undelegated powers, its acts are unauthoritative, void, and of no force. Now, I think that makes it clear. And I think the American citizens ought to press their governors, their state governors, and legislatures just to nullify the law, just to plain nullify it and say the citizens of such and such a state don't have to obey ObamaCare because it's unconstitutional, regardless of what the Supreme Court said. Well, maybe we have a governor with the courage. This is a story carried in the Washington Times, July 2nd. It's an exclusive interview with Florida Governor Rick Scott. He said, referring to Obamacare, I will not implement this law. Florida will not implement Obamacare. Now, that, my friends, is a governor with guts. Now, before somebody calls up and says, well, Williams, the reason why Congress can do this, it's covered by the General Welfare Clause. Here's what James Madison said in a letter to Edmund Pendleton in 1792. If Congress can do whatever in their discretion can be done by money and will promote the general welfare, the government is no longer a limited one, possessing enumerated powers, but an indefinite one. Thomas Jefferson said the same thing. He says that Congress does not have the authority to do anything in the general welfare, but only those that are enumerated in the Constitution. And so I don't find any enumeration for health care in the Constitution. I do not even believe that the word health appears in the United States Constitution. So if it doesn't appear there, well, they can't do it. And that's what the enumerated powers mean, ladies and gentlemen. It means that if it is not among those 21 things that are listed in Article 1, Section 8, well, Congress cannot do it.